And I have Honorable Samson Osage. Dr. Samson Osage is a lawyer and a former member of the House of Representatives, of course. Will be joining us on the program tonight. But let's give you an update of what is happening out of Rivers State. Today, the Rivers State Commissioner for Justice and Attorney General is already reacting to what has happened. But earlier today, the High Court sitting in Rivers, in Port Harcourt, today affirmed that Mr. Martin Amawe and 26 other lawmakers who defected from the PDP to the APC remain members of the PDP, according to the court today, that membership of a political party can either be in two ways, either by membership or by being enlisted as members. And he said that defection does not stand, and as such, they remain members of the House of Assembly in Rivers State. Of course, the Rivers State Commissioner for Justice and the Attorney General has been reacting to the judgment coming out of the High Court today. Let me allow you to listen to the Attorney General of Rivers State, who's been reacting, disagreeing with the position of the court today.
The court clearly stated that Right Honorable Martin Chike Amehule remains the Speaker of the State House of Assembly, as well as other members are quiet and remain members of the State House of Assembly, and their laws, the laws that are passed are legitimate, and the state government is bound to obey the laws passed by these honorable members. That's exactly what the court said this morning. Well, I'm sure that you heard the court. A lawyer from the PDP came and said that they remain members of the PDP. As far as their record is concerned, they have not left the party. They are still members of PDP.
All right, let's get some insight on this one. Someone who is very experienced is probably senator in terms of these defections. Interestingly, he's a lawyer, and he can also give us some insight on what this means for our politics. Dr. Samson Osage, former member of the House of Representatives. Thank you so much indeed, Honorable, for joining us tonight. Give us an insight on what to make of the decision of the High Court, which the Attorney General disagree with. The High Court said, look, those members, 27 of them, who defected from the PDP to the APC, still remains members of the PDP, and that you cannot use any ceremony or television program to declare your membership of a political party. It can only happen via two ways. According to the court today, the High Court says it can happen when you are enlisted officially as a member of the party or by carrying the membership card of the party. What are your views on the decision of the court today?
Well, thank you, Sean, for having me. And I would like to start on the note that the issue of political defection is a constitutional matter which has been given judicial interpretation in several cases, amongst which are almost the locus classicus, Abegude and the Ondo State House of Assembly. In this particular judgment, where the Rivers State High Court had heard that the 27 members of the Rivers House of Assembly who had last year declared their membership of APC from the PDP as still members of the PDP appears to be strange, because even though the court, in my opinion, was right in saying that, to become a member of a political party, you have to be enlisted in the register of the party. You also have to carry a party card. But in the instant case, it will appear to me that the 27 members of the Rivers House of Assembly publicly declared their membership, and there are the electronic evidence to that effect. And the 27 members themselves have not denied, even up to now. What I think is that, depending on the issues that were submitted to that court for interpretation or adjudication, the court seems to be placing the burden of proving membership of a political party on the plaintiffs or the claimant in that particular instance. But it is important to state that Section 109, subsection 1G of the Constitution makes it quite clear as to what will happen if any member of the legislature, particularly the House of Assembly now, defense from a political party that sponsors this election, except, of course, if there are clear divisions in the party, which makes the party not to be able to function properly. So, strictly speaking and legally speaking, political defection has been outlawed by the Constitution of the Federal Republic of Nigeria. But however, there are exceptions, and those exceptions are meant to be proven by a party who seeks to change his political party platform for another party. So today's judgment is one that should require further judicial intervention, at the Court of Appeal level in order to ascertain. It has moved the issues from losing your seat from decamping from your party to membership of a political party. The question is, what are the criteria for determining the membership of the political party? That is the legal issues that have been raised by today's judgment. And I am sure that the higher courts will have to intervene to give proper interpretation to what constitutes membership of a political party and how somebody can acquire membership of a political party given the circumstances of this particular case.
One of the issues raised, which I would like you to also clarify, the Attorney General of the state is also speaking about jurisdiction of the court of the state high court in hearing a conflict between the state assembly and the issues of defection of a state lawmaker from their political party, and as established in Abegunde versus Ondo State House of Assembly, it was also established that you have to be able to define what a crisis is in the political party, and not just in the local level. It has to be at the highest level of the political party. And so the Attorney General is saying that by the provision of Section 272, subsection 3 of the Nigerian Constitution, that the High Court of the state does not have jurisdiction to hear the matter of defection between the lawmakers and the State House of Assembly. What do you make of that position?
Perhaps that explains the position of the law with respect to that issues. But I wouldn't know if that argument was canvassed before the particular judge who delivered this judgment today. If that issue was not canvassed before him and he did not raise the issue suo motu as a threshold matter to be determined before entering into the merit of the case, then it can be a matter for an appeal because you can raise it at any point in time. But the truth is that the Federal High Court is seized, with issues relating to conflicts arising between two tiers of government or intergovernmental relations. So I agree that when it comes to issues between a political party, between a tier of government and another tier of government, and it involves an agency of government like the INEC, which is necessarily a party in this matter, the Federal High Court is seized of the jurisdiction. It is not just a fundamental right case that both State High Court and Federal High Courts can adjudicate upon. So it is correct. But if he didn't raise it at the trial court where this judgment was given, then it may have been a negligence on his part, and he may have the opportunity on appeal, to raise the issue of jurisdiction. And it is a very crucial point that must be canvassed. So
what then happens when there is a subsisting interlocutory injunction that Amaule and 26 others should not parade themselves as members of the assembly? Now you have a court of coordinate jurisdiction, you would say, ruling in same matter. What happens? And look, in the eye of the state, it said, look, disregard the judgment of the State High Court because there is a subsisting interlocutory injunction saying that they should not parade themselves. How then do the public interpret this?
Well, that is a conundrum that the judiciary needs to sort out for the justice system of our country. It is not unfamiliar to us that there have been conflicts of judgments and conflict of orders coming from different courts. And when the Kano Emirate tussle took place, we have different courts of coordinate jurisdiction issuing orders on the same subject matter in different directions. And I think that does not speak well for our justice system in this country. I think part of justice reform system must be to ensure that there is some level of consistency in the judgments that comes out from our courts, especially courts of coordinate jurisdiction. It is embarrassing to the justice system that courts of coordinate jurisdiction are giving conflicting orders or conflicting judgment on issues. Of course, I also know that no two cases are exactly the same, especially on facts. But where cases are essentially the same on facts and the same law applies, one will expect that the reasoning of the courts must be consistent with the law. And if the reasoning of the courts are not consistent with the law among courts of coordinate jurisdiction, then it raises cause for concern. For example, the tribunal cases that has to do with judges, members of the House of Assembly, National Assembly, and of course the governor, is still a very worrisome one as we speak. So this is one of the challenges facing the judiciary today, that there is no consistency in the judgments coming out from courts of coordinate jurisdiction with respect to matters on the same subject matter and largely within the same ambit of the law. And I think that it is a cause for concern for both practitioners of the law, judicial officers, and the entire justice system.
Perhaps one way to wrap up this conversation is to ask you, where does Rivers State go from here if there are disagreement, because it's the political disputes that led to the parties involved to go to the court, looking at the rest, looking at the substantive matter of this case, asking the question before the court, are these members still members of the House of Assembly? If these are the prayers that they should have lost their seat based on established court decisions or based on established laws of our land, if there are still disputes after a court today had ruled in that sense, where does the people of Rivers State go from here, or where should be the way? What should be the way forward at this instance?
For me, I think there are two options. The first option is the political solution, by which all the political gladiators in the river political conundrum at this point in time must seek the interests of Rivers State as uppermost in ensuring that governance is smooth and that peace and order is restored to the state without bickering and without any attempt to divert attention from various issues that are besetting the state, in terms of management of the economy of the state and the development of the state in general. So a political solution is most likely, to provide solutions to all of these challenges. Then the second option is giving the litany of court cases and judicial matters that have been filed in respect of the Rivers political imbroglio. Then we have to wait for the Supreme Court, which is the final court of the land, to make a final pronouncement. But of course, given the slow nature of our justice system, that will take a long time, even up to the end of the tenure of this administration, before we can ever get an end to these judicial agitations and judicial cases that are before the various courts. So it is my humble opinion that if Rivers must be spared of the agony of going through a tumultuous tenure in which the political gladiators that have been elected are up in arms against one another, the various leaders of that state must come together and take the interests of the state above their own personal and parochial interests. That is the fastest way that these issues can be resolved. Otherwise, we may have the final judgment of the Supreme Court in any of the matters, even in 2027 and even beyond. And that will not be in the interest of the state. It will not be in the interest of the stability of the state. And it will not augur well for the consolidation of democracy in that state. And of course, it will affect the democratic consolidation in Nigeria.
Interesting scenario playing out in Rivers State, and Rivers State has never been without some political disputes or drama that we've seen in the past days and weeks and months, and perhaps we'll be hoping to see maybe an end to it for the interest of the Rivers people. Thank you so much indeed, Dr. Samson Osagie, a very senior lawyer and a former member of the House of Reps. Thank you so much indeed for sharing your insight and perspectives on this matter with us tonight.
Thank you, Shehu, for having me. I recall how you escaped some bullets years ago in River State.
Yes.
But thank you are alive to tell the story. Thank you very much.
Thank you so much. I appreciate it.